Hi, I'm Ron Turner. Welcome back to the Constitution in a nutshell. Today we're going to resume our story by going through the Constitution itself. We've already looked at Articles 1, 2, and 3, so we'll pick up with Article 4. Article 4, Section 1. Full faith and credit shall be given in each state to the public acts of every other state. It means what it says. Article 4, 3. No person held to service in a state escaping into another state shall be discharged from such service, but shall be delivered up on claim of the party to whom such service may be due. If you didn't know what that was about, you wouldn't know what that's about. Slavery. Yes, indeed. The Constitution never uses the word, but this is one of several references to slavery without talking about it, where slavery is actually approved. It was a huge issue at the Constitutional Convention. We'll talk more about it in some detail later. Article 4, Section 4. The United States shall guarantee to every state a Republican form of government. Wait a minute. That means we all have to be Republicans? No. How about the Democrats and Independents? What in the world are they talking about here? Guaranteeing a Republican form of government. This talks about the difference between a republic and a democracy. In a nutshell, in a democracy, every voter votes on everything, and the majority rules, and that's that. That would work if we had a village of about 50 people and they could all get together once a month and vote on things. Once you get much larger than that, you group people into smaller groups, and that group votes for someone who represents them in another group, like a student council in a school, or Congress, where you live in a district and all the people in the district will elect a person to go to Congress to represent you. That's what a republic is, and that's what we're guaranteed by the Constitution. Article 5. The Congress, whenever 2/3 of both houses deem it necessary, shall propose amendments to this Constitution, or shall call a convention for proposing amendments, which shall be valid when ratified by 3/4 of the states. That's starting to sound like legal gobbledygook. I tried to cut out as much legalese as I could, folks, but basically this is telling us there are two ways to amend the Constitution. One is for Congress to vote on some amendments and send them to the states to approve them. Second is for a convention to be called by Congress, and then the people at the convention will propose amendments. We haven't had a constitutional convention since 1787. There are some people who favor calling a convention today so that the Constitution could be updated. I would be very, very cautious about that for a number of reasons, and I'm not going to spend a lot of time on this, but there would be the possibility, if you call a second Constitutional Convention, that you would inadvertently open up the entire document to being thrown out, starting all over again. I think that would be a disaster. Secondly, we know from the role that money now plays in politics, if a Constitutional Convention were called today, guess who would be paying the best lobbyists that they possibly could to try to convince the people at that convention to vote in favor of them? You better believe it. Money would rule it. That would be a disaster, in my opinion. Article 6. This Constitution shall be the supreme law of the land. That's a short sentence as well as some of the earlier ones that we looked at, but it was a crucial problem under the Articles of Confederation because there was no real understanding or clear-cut decision on which law prevailed. Each state was sovereign, each state was independent, so there was no way they could have interstate commerce or be protected from foreign invaders and so forth. So now the federal Constitution is the supreme law of the land. Article 6, Section 3. No religious test shall ever be required as a qualification to any office under the United States. That's one of those provisions. It's in the Constitution, the same as freedom of speech, but most people probably either aren't aware of it or have forgotten that it's there. The concept of separation of church and state is very clearly in the Constitution of the United States. I want to make that crystal clear. It's not ambiguous. You might not agree with it, but it's there, and we're going to talk about it in much more detail in the First Amendment. But this is a perfect example of it. If you want to hold an office in the federal government, the government cannot talk to you about what your religion is. It's unconstitutional. Article 7, the ratification of the conventions of 9 states shall be sufficient. Remember, we had 13 states at the time. And the drafters said, if only 1 or 2 states agree to this, that's not going to work. We need a pretty good number of them. So they came up with the number 9. As soon as 9 states ratified the convention, and it was sent out in 1787 to all 13 states for them to vote on them, then it would become effective in the states that had actually ratified it. As it turned out, by 1789 actually, all 13 states had ratified it. Maybe the 13th state did it in 1790. And then there have been amendments. The Constitution includes a preamble, 7 articles, which are actually fairly short, and then 27 amendments. Guess how many amendments have actually been introduced in Congress over the last 240 years? Over 10,000. Wait a minute. I'm not sure I can even do the math. What percentage is 27 of 10,000? It's infinitesimal. Some people would say, that's great. The Constitution should be hard to amend. And other people say that's one of the problems with it. When automobiles were developed or invented, we should have amended the Constitution to include them. Well, if you did that with every invention, the Constitution would be a disaster. It'd be unworkable. But any member of Congress has the authority, any single member of Congress has the authority to introduce a potential amendment to the Constitution. And 10,000 of them have been over the years. But only 27 have gone through the entire process of being ratified. And I've already discussed the 2 ways to amend the Constitution. Either Congress can prepare them and send them out to the states, or can call for a convention. Of the 27 amendments that have been passed, the first 10 were approved, ratified by the states as a package, and that's what we call the Bill of Rights. You may remember that the Constitution itself really doesn't talk about individual rights. It talks about the structure of government, it talks about the power of each of the 3 branches of government, but many of the delegates at the Constitutional Convention almost didn't vote for it. The whole convention almost fell apart because they felt strongly that freedom of religion and freedom of speech, etc., should be included in the Constitution. There were other members at the convention who said, let's not push for it right now because it was debatable. There were many holdovers from the Articles of Confederation who thought that you didn't need to get into all of those individual rights in the Constitution, so there was a lot of conflict. But the folks who were supportive of a Bill of Rights were convinced that as soon as the basic Constitution was ratified, a Bill of Rights would be submitted as amendments to it, and they would also be ratified. And that actually happened. By the end of 1790, all 10 of the first 10 amendments had been ratified. Let's take a look at the First Amendment. I'm not going to get into all of them, but the First Amendment is the biggie. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. Now that last one should sound somewhat familiar because that language is right out of the Declaration of Independence. Before we separated from England, the colonists petitioned for redress of the grievances they were suffering under King George, and they were basically told to go jump in a lake. But this amendment, it was placed first on purpose. It's not just by accident, because these 5 freedoms, these 5 rights, were so important to the drafters of the Constitution. And freedom of religion was put first out of those 5 because it was the most important. There's no question. You hear people claiming now, and I don't understand where it comes from, that separation of church and state is not found in the Constitution. Well, the exact phrase isn't found, but certainly the concept is, and it's there right there. freedom of religion, I'm going to reread this part of the First Amendment and then talk about each clause. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. First of all, it says Congress shall make no law, so it sounds like they're only talking about the federal Congress, and the state governments could make a law establishing a religion or prohibiting free exercise. The Supreme Court has held for many years that this amendment applies to states as well as the federal government. I won't get into the details of that. I'm not going to be citing Supreme Court cases in this program. But this applies to all levels of government. So government will not pass a law respecting an establishment of religion. Some of the colonies had official religions. If you didn't belong to that religion, then you were breaking the law, and you actually had to pay taxes to support that one church. Well, the framers of the Constitution believed the government should not establish a particular religion. They don't want the government saying everybody's got to be a Baptist or a Methodist or a Catholic or whatever. Okay, so freedom of religion means the government will not establish a religion. The second part of that is that the government will not prohibit you from exercising your religion the way you want to. It's a balance. It's a balance. You have the Establishment Clause where the government is not going to have a government-supported or sponsored church, and you have free exercise. That means you can go to church wherever and whenever and however you want to. Now, obviously, if you decide at your church you're going to start sacrificing virgins, that will not be supported because society just can't go with that. But you are free to be a member of the Church of Christ, Jewish, Catholic, Baptist, Presbyterian, atheist, whatever your religion calls you as an individual to be. That's probably enough right now on the First Amendment. And that concludes our quick look at the Constitution itself. I hope you will go back and in a few days maybe watch this particular session or this one and the one that immediately preceding again, because we've been looking at specific language right out of the Constitution itself. If you like what we're doing here, please click like and also send me a comment. Whether you are supportive or you can give me some ways that I can improve this program, I would love to hear from you. Subscribe to my channel if you'd like to see more videos like this, and share it with a friend. Thanks. I'll see you next time.